Welcome to the second SEC Roundtable panel on executive compensation disclosure requirements. I am James Cotton. I want to start by thanking the SEC on behalf of the entire panel for providing us with the forum to discuss executive compensation disclosure rules with you. As noted during the first panel, I will now formally introduce our panelists. We want to preserve as much time as possible for the discussion today, but please review their impressive bios on the SEC website. During this panel, we will review two very hot executive compensation disclosure topics, perks and the NEO rules. But before we review those topics, we're going to tackle that million-dollar question that Chairman Atkins posed when this roundtable was announced, and also underlines his comments from earlier today. That question is, with the experience of almost 20 years of implementing the 2006 rule amendments, how can the SEC address the challenges that issuers and shareholders have with the executive compensation rules as they now stand today? To properly set the stage for this conversation, I want to ask Mark, to level set for us by providing a brief overview of how we got to the 2006 amendments.
Thanks, James. I'm going to just spend a couple minutes talking about how the SEC's rules, which have been around for various forms for 75 or 80 years, have been updated over time. It seems like it's been a constant game of cat and mouse between the SEC revising the rules, then a few years later, compensation practices and strategies change, and all of a sudden things don't mesh very well. There are two sets of rules that are worth noting because the SEC has made some fairly significant revisions to the disclosure rules in the last 30 years, once in 1992, and then again more recently in 2006. The 92 revisions are worth understanding because they basically established the framework upon which the current disclosure rules were built. At the time the rules were changed in 92, the change was pretty dramatic and pretty drastic from what the rules had been before, which was primarily a hodgepodge of narrative and tabular disclosure. Instead, in 92, the SEC went to a heavily tabular disclosure approach, but introduced two concepts which, as you'll see momentarily, are sort of foundational to the 2006 rules. First of all, they introduced the concept of the summary compensation table, which was obviously spoken about a bit in the past panel, an element-by-element breakdown of the compensation packages of the company's senior executives, the so-called named executive officers. The other thing they did was they introduced the so-called Board Compensation Committee report, which was a narrative description of basically two things: the company's executive compensation policies, and then the decisions as to how the CEO's pay was determined in the prior year. And to emphasize the importance of that disclosure, this table had to be presented over the names of the compensation committee members. Well, as you probably know, with the passage of time, the SEC began to focus on whether those rules needed to be updated. And in 2005, they undertook to consider revisions to the rules for three reasons, basically. One, they wanted to update the 92 rules to reflect company and investor experiences with the rules. Secondly, they wanted to address the continuing evolution of pay strategies and techniques, which had gotten to the point where they were outpacing the disclosure of the 92 rules. And then third, they wanted to address concerns of shareholder activism, which were looking for more transparency in the compensation pay-setting process. The SEC went through its normal review, proposal, and comment process, and then made the changes to the 2006 rules. And I kind of put those into three categories. First, they introduced the compensation discussion and analysis, or CD&A, essentially a narrative discussion analyzing the company's comp program, explaining the pay decisions for the prior year, and providing context for the accompanying compensation tables. The thing that's important to note about the CD&A were the two fundamental tenets that understood that particular disclosure. The first is the disclosure was to be principles-based, and secondly, that it was to be written in plain English. We're going to talk a little bit more in this panel, and we'll probably follow in the third panel, as to whether or not somehow we've gotten away from this principles-based focus that the CD&A was supposed to provide. The second important change in the 2006 rules were the retention of the summary compensation table with two significant modifications. First, a total compensation column was added to the table, something that didn't exist under the 92 version. Second, in order to accommodate this change, the reporting treatment of equity awards was revised. You may not remember, but in the 92 table, compensation was reported in cash except for equity awards. Equity awards, you gave the number of shares granted. The 2006 rules required that awards be reported using a dollar amount calculated based on the award's accounting fair value. Now, I just want to go to a short sidebar before I turn it back over to James. It's sort of difficult to understate the significance of this latter change and how it foreshadowed the ongoing debate about how to value equity awards for disclosure purposes, which is something that's going to be a constant theme in these remaining two panels. Originally, the rule as adopted in 2006 required the reporting of the full grant date fair value in the year that the award was granted. That lasted about 4 months, and at the end of 2006, the SEC issued immediately effective interim rules which changed the way that equity awards were reported so that they were reported instead on the basis of the fair value that was being recognized in each covered fiscal year for financial reporting purposes. So if you had a 4-year award and the compensation expense was allocated over 4 years, then that award was disclosed over 4 years with respect to each of those different installments. This change, as you would expect, led to significant compliance issues, widespread investor confusion, and an increasing chorus of complaints that caused the SEC to return to the one-time disclosure of the full grant date fair value method, which is what the rule requires today. Finally, the rule took all of the supplemental compensation tables and sort of put them into two buckets. The first one was a set of tables almost exclusively focused on equity awards, which somewhat imperfectly tracked the life cycle of such awards from the time of grant through the time of realization. And then secondly, a set of tables that provided the accumulated retirement benefits that the executives were eligible to receive, as well as the amounts payable under the severance and change of control arrangements. And I think we're going to be talking a little bit more about those particular provisions in this panel and perhaps even in the next panel. But that's basically how we got to where we are today and the challenges associated with that.
Thanks for that. And giving us a better understanding of those 2006 amendments, and in particular where the heart of the executive compensation disclosure rules or proxy disclosure comes is with the introduction of the CD&A's section. But Dave, can you now go into some of the major rules that were added after the 2006 amendments were implemented?
Certainly, yeah, and I think based off of the commentary we heard from the chairman and the commissioners and the prior panel, these are the rules that everybody loves to hate here that I'm going to talk about. But I'm going to start off with, and these rules really emanated from principally the Dodd-Frank Act of 2010, and there were a couple themes, I think, that go through these rules that are important to keep in mind. The first one, I think, when we look at these rules as how they've been implemented, is that so much time passed between when Congress enacted the statutory directives and the Commission acted in the case of many of these rules that basically the world kind of moved on. And you can see that in the context of the clawback rule that we'll talk about in a second. You can see that in the context of pay versus performance, where through private ordering companies had already made disclosures about realizable pay, realized pay approaches, and the CEO pay ratio. I'm not sure the world ever moved on from that, but that really wasn't a thing, I guess. And so the one thing that I think is important from the Dodd-Frank era that is surprisingly maybe the least hated of all of the rules is say on pay, which one might have expected people would more have enduring problems with. But what I think was interesting about say on pay is it's not really a disclosure rule, but it really changed disclosure significantly. If you go back and look at proxy statements before say on pay and after say on pay, there's a marked difference in the approach that people took. And I think that is important because it was what say on pay ushered in was this sort of era of more engagement and more discussion and sort of more higher and articulated expectations from institutional investors and proxy advisors about the type of transparency and the type of information that they expected. And I think a point that Bob made on the last panel was a really good one, that sometimes that means a lot more additional disclosure, such that you ask yourself, even if the SEC were undertake an effort to pare back disclosure requirements across the board and companies would be obligated under SEC rules to disclose less, would companies still have to disclose just as much or maybe more because they're continuing to have to meet expectations of investors through a say on pay process? So I think from my sort of ranking, that one had kind of the most outsized impact on how we write our disclosure, how we present our disclosure, and why we provide our disclosure about executive compensation in so much detail. I think others have already mentioned basically the two principal concerns I think people have with these post-2006 rules, and that would be pay versus performance, where I think that the statutory directive was reflecting a concern that had emerged and had been a persistent concern for many years on the topic that Mark just talked about. When you have a summary compensation table that's based off of either grant date fair value or the amount expensed for compensation, it isn't really showing what someone actually earned or received or was paid in a particular period, an annual period. And so there was a thought that it was very difficult to align the performance over time with the compensation that people actually were receiving. And that's why, in a private ordering world, people were coming up with alternatives, including the proxy advisory firms creating their own alternatives to that sort of total compensation, summary compensation approach. Now, I think on the way to adoption over the course of a very long period of time, that calculation of compensation actually paid that ended up being an ultimate rule, everyone seems to agree that that is a very complex calculation that makes it hard not only to produce the disclosure, but to actually interpret the disclosure and compare the disclosure across companies. I sometimes, say that it's sort of disclosure written by economists for economists. And I think that's a concern when you write a disclosure requirement that is so prescriptive and so complex and using, sort of valuation methods that are subject to some determination on the part of companies. It's not as an effective a disclosure as if you had perhaps given people just some direction and allowed them to come up with their own measures. And then I think the other major role was CEO pay ratio, which I don't know that there's a whole lot to say about that one that hasn't already been said, but obviously it was, it to me demonstrates sort of the difficulty of having rules, disclosure rules written by the legislature as opposed to by the agency, because when the legislature was writing it, it wasn't subject to notice and comment and consideration. Now, the SEC did have a lot of the benefit of that when they adopted the rule, but again, we came up with because of the difficulty in sort of boiling down the median employee pay relative to the CEO annual total compensation, complexities were inevitable, and I think that's been one of the limitations of that rule. Certainly, is just, again, is it something that you can easily interpret and compare from company to company? And I don't think it's met that objective. And finally, I think the other Dodd-Frank era rule that isn't really a disclosure rule, but again has been raised as part of this of the chairman's statement about this process, is the callback recovery provision, and that's clearly one I think falls into that category of the world moved on. Companies in the aftermath of the financial crisis, many companies adopted as a good governance practice clawback policies that were sort of tailored to their particular circumstances, and instead, because of the statute and because of what the SEC decided to ultimately do, we now have to live in a world of a one-size-fits-all policy that I think creates a lot of difficulties for companies in ultimately applying those in the event of a restatement.
Thanks. Roland, I'm going to go to you all the way on the other side of the table. Let's bring you into the conversation. What do you think about this evolution of the executive compensation rules, in particular, when looking at how companies tell their executive compensation story, which is, for all those Star Trek fans there, our prime directive, telling a clear executive compensation story? What are the requirements in the CDA section or elsewhere that make that storytelling harder to do?
I appreciate the question, James. Thank you. I'd be remiss, and I know my colleagues have done the same, to thank the SEC and the chairman and the commissioners for providing the platform for this conversation. I think it's a really important one to have, and I appreciate it. It's a good opportunity to step back, to reflect our disclosures. Are the disclosures meeting the objectives? And it's an important opportunity for us to consider that. The thing that I'm reflecting on, listening to this panel and the panel before, it's really encouraging to see that we've got some common ground in terms of understanding that we've got clear, transparent disclosures that provide investors with meaningful information that supports well-informed decision-making. And Mark and David did a really nice job providing a description of what that evolution has looked like. And as we've seen the rules evolve, there has generally been an additive approach. We heard on the prior panel, more is better, perhaps. I think it might be useful to answer some of your question, James. I wanted to add a little bit of a flavor, a little bit of a color around what does that evolution look like in terms of the actual disclosures that people are seeing. So prior to 2000, our CD&A averaged about 5 pages in length. 5 pages. With the introduction of new, more complex, and often unclear disclosures, our CD&A sits at about 35 pages today, in part because we spend much time providing clarification to the required disclosures. Now, what's particularly interesting about that is not necessarily the 5 to 35, but though our CD&A has increased 7 times now over the last 2 decades, our executive compensation program remains unchanged. Our narrative remains unchanged, and our strong linkage between pay and performance remains unchanged. So we regularly engage with our investors, and the vast majority of those discussions focuses, and I would say appropriately focuses, on the core principles, and that's been discussed before as well. Core principles of our program, our performance, and the resulting pay decisions. So we ask, James, you asked me, so has the expanded length and detail of the CD&A effectively advanced the policy objective? Has it provided investors with a clearer, more comprehensive understanding of executive comp? I would say, based on the conversations that I've been able to have with our investors, I don't really have evidence of that. So you ask me what I'm thinking shorter, simpler disclosures. I think it's clear that a framework is necessary. I think it's clear that rules are required, but we've made it way more complicated than it needs to be. We've created an industry in developing, explaining, and then evaluating disclosures. So, what I'd say, articulating performance and pay should not take 35 pages.
I was going to try to keep myself from providing too much commentary, but I'll say a little story. So at United, we revamped our proxy statement a couple of years ago, and I sent the final draft to someone who helps us with our proxy, and they responded back, can you tell me what I need to focus on? Because, all of this is pretty boilerplate. And I got offended, like, oh my gosh, all this work that I did, and you're telling me it's boilerplate? But when I took a step back, I kind of understood where she was coming from. Anyways, I'll stay on the other side of the table and bring Brandon into the conversation and ask you that same question from the investor perspective. When viewing companies' executive compensation disclosure, are there requirements that companies need to satisfy that may be a little boilerplate that are hindering your ability to easily assess companies' executive compensation programs?
Thank you, James, for the question, and thank you for the SEC for allowing me to join as an investor on this panel. And I especially appreciate the water in today's heat wave. I know with the Doge era cutbacks that it cannot be depended on, but I apologize to those in the audience who may be thirsty, but there is a vending machine in the hallway. So the problem with executive compensation disclosure is not that investors are receiving too much information. It's that the executive compensation plans are too elaborate. Frankly, if I was an alien from another planet trying to learn about human society and I read a corporate proxy statement, I would probably come to the conclusion that senior executives are the laziest people on earth because they need so much incentive in order to wake up and do their jobs in the morning. Now, I don't actually believe that to be the case. I believe that executives are dedicated and hardworking people. But it is astounding just how many different compensation opportunities are being given to senior executives. Regarding the level of disclosure, though, investors, we are perfectly capable of focusing on the aspects of executive compensation that is most important for our analysis. No investor is asking the SEC to reduce the amount of disclosure. And I would note that reducing the level of disclosure for compensation-related information is likely to have unintended consequences for corporate issuers. The average say-on-pay vote this year is over 90%, and 99% of say-on-pay votes pass. Reducing transparency will likely result in higher no votes on executive compensation. Changes to the summary compensation table presentation are particularly problematic. We've been relying on this table presentation since 2006. Despite my youthful appearance, I actually did read proxy statements before the changes, and I can tell you that it has been invaluable particularly for say-on-pay voting by institutional investors, as well as voting on director elections for compensation committee members. The summary compensation table methodology reflects the fair value of compensation awards that were made in the year in question, and that is precisely what investors are voting on when voting on say-on-pay. Other methodologies currently required, compensation actually received, or alternative methodologies like realized compensation disclosures. Those are helpful supplements, but investors need to be able to evaluate the board's decision-making in the year in question, and that is the grant date fair value of equity awards and the other compensation contained in the summary compensation table. Now, there's one issue that I will highlight as my recommendation for the SEC to consider where there is a major problem in executive compensation data presentation and proxy statements, and that is that this problem makes us as investors, particularly smaller institutional investors, more reliant on proxy advisors. And that's that the summary compensation table data and other quantitative disclosures in the proxy statement are not machine readable using XBRL or other alternatives. I can download the financial information statement in real time from the annual report, from the 10K, but for the proxy statement, that is simply not available. For this reason, we as institutional investors are dependent on the proxy advisory services to aggregate that data and to help analyze it. If issuers want to reduce our dependence on proxy advisors, they need to support requiring that the SEC mandate that this be disclosed on a uniform basis across issuers in a machine-readable format so that we can conduct our own economic analysis when making say-on-pay votes. With that, I'll turn it back to you, James, and look forward to the conversation.
Thank you for your remarks. I can't argue with you on the complexity of executive comp programs. I remember when I was a first year at Sherman, I called my wife, who was at another major law firm, and I was like, well, I feel pretty lucky. I'm on a matter where I get to draft proxy disclosure, but I just read the CDNA and I don't understand it. Let me bring.
It's an acquired skill.
Yes, it has been. It has been. Let me bring Mike into the conversation, and I would be interested to get your thoughts on that same question from an investor perspective, but also how the rules can better highlight aspects of companies' executive compensation programs that you think that it would be helpful for investors like you to understand.
Okay, thanks, James. And I would also like to thank the SEC staff, Chair Atkins, for conducting today's roundtable. I agree with much of what Brandon has said, especially the XBRL kind of machine readable. I think that's something that is, I hope, is going to happen sooner rather than later. I think that would make everyone's lives quite easier in terms of analyzing data. But I think from an investor's perspective, from my perspective as well, two of the central challenges for investors and within the current executive disclosure framework, it's twofold. It's navigability, finding the information, and its comparability. It's kind of the standardized data where we can consistently apply, kind of to Brandon's point as well. And while the CDNA section provides substantial narrative content, it's grown over time. Volume is not the problem. Quality is the deficiency in many investors' minds. The format can be inconsistent across different companies. Many firms focus more on just justifying their practices than really enabling investors to use the information to make proper analytical decisions, ultimately proxy voting decisions. And as Chair Atkins pointed out at the outset, investors really benefit from plain English disclosures. The generic boilerplate legalese is really not helping anybody. It's been a longstanding, I think, criticism from the investor community, CII, et cetera. But that's really, if you can do one thing without getting into the weeds of some of the specific disclosures, if that can be improved and the quality can be amped up, I think that would be a huge gain. So a couple of ideas, James, in terms of, and I tried to keep them, high level without getting too specific, but a couple of areas that where I believe the disclosures could be enhanced and improved. One is really anything having to do with a clear connection between pay and performance. There's a lot of standardized tables, summary comp, et cetera. But in terms of standardized information where you can reconcile, specifically in my mind, awarded versus realized pay with long-term performance benchmarks. As an investor, we're obviously biased towards total shareholder return, so TSR is kind of central, but other capital measures, return on invested capital, economic profit, other non-TSR metrics, I think can be beneficial as well. One could propose a graph where you would display the kind of the relative pay for relative performance. I think that's how a lot of investors, when they're, especially if they're indexed or they own highly diversified investors, they own a lot of different companies, a lot of industries, they like that comparability. That would go a long way in helping them enabling them to make better decisions from a voting perspective when they evaluate that pay versus performance relationship at the companies, and specifically over longer time frames. So we talked about, I think panel one covered that at length in terms of like the 5-year and or longer time frames. Two would be granular performance objectives or goal disclosure. That's something that we really dig into when we're making voting decisions, including the specific targets set for annual and long-term incentives, along with the actual award thresholds, which is kind of a pet peeve. It's very hard to understand how the pay plans work if we don't know at what point the actual earnings are being made, the award is being made. Along those lines, complete definitions of the performance objectives, that can be something that investors struggle with, that could be improved. And then the rationale essentially for the metrics and how they're calibrated, kind of think moving away from that pure relative percentile score to much more explicit definitions in terms of how they're structured. Annual incentive plans are, kind of notoriously opaque in our view. In terms of defining the performance objectives, you essentially have a laundry list of potential metrics, and then how that attribution within the specifically on the annual plan side, annual incentive plan side, is actually conducted along with discretion. Scenario-based disclosures that show how different performance outcomes can change the total realizable pay, I think would be beneficial, especially for any equity awards. And then kind of last but not least, kind of improved disclosures around the discretion applied by the compensation committees. I think that would be very beneficial, along with justification and the impact on total pay outcomes. Like how, not only how is that discretion applied, but what was the impact to total pay. Especially important, and many companies do not do this. It might be a little maybe naive or idealistic to kind of think this, but it would be very, very helpful, is an explanation by companies when the pay versus performance relationship deteriorates, the pay plans don't work very well. Explain that. Explain why, what was driving that. Was it an industry effect, which I think investors in many cases would assume, but you simply don't get that type of kind of either a narrative or tabular explanation. I think that would be very helpful. Back to you.
Thanks. I'm going to go to Zach, my other issuer friend on the panel. Issuer friend, Zach. What aspect of the rules give you annual heartburn to comply with? I know I've been taking some Tums recently.
Yeah. Thank you for that. Just quickly echo everyone's sentiment. Thank you to the staff for organizing this and for the commissioners and the chairman for taking the time to give their views and to listening to our input here today. I thought there was a little bit too much agreement on the first panel, so I'm glad that kind of at the outset here on the second one, we really got investors.
I can't say that was my goal.
Yeah, we're going to get after it here, so I appreciate that as well. No, it's great to have the opportunity to get all this stuff out in the open and work through it. So we heard an ice cream example. Commissioner Pierce used the forest for the trees kind of analogy. I like to think about the rules as sort of like a Venn diagram. And when the SEC says we want a principles-based approach to executive compensation disclosure, I think it's really about the overlap in the diagram among, what is the board and the comp committee really talking about and doing in the context of setting the program and making decisions regarding pay outcomes. On the other hand, it's what's really material for investors to make investment decisions, evaluate the effectiveness of the board and overseeing management. And third is really what are the internal resources, the in-house members of management spending their time on to translate those two pieces into the disclosure. Forget the lawyers and forget the comp consultants and the outside advisors. I don't think the SEC intends to proliferate, that industry, and they really want to be focused on how companies are using the capital that issuer, that investors give them to, turn around and make decision useful information and describe what's going on. And that overlap, I think, is where, the principles-based approach really sits. And I encourage, kind of the commission as they're thinking about this stuff to try to get at the heart of that. And the other stuff, the rum, raisin, ice cream, kind of, we should really try to streamline that or excise that as much as possible. And, to directly answer your question, I think there's kind of two areas. There's a lot, but I want to focus on two areas where the present rules really impact, the program, the process, and the actual process of putting out the disclosure. The first is, and I know the commission is very focused on this, and the investor community as well, is boilerplate. The fact of the matter is that one of the interesting things that didn't come up on the first panel about the process of compensation is the idea of the time of year that it's happening and the insane time crunch that goes into closing the books so you get the actual results on the performance measures, getting the meeting set up, having the decisions of the comp committee translated into the performance program and communicated out, and actually the administration of the bonuses and paying that all out. And it's in no one's best interest to have a comp process drag out and past the first quarter. So you're really trying to get everything done, and you're on the clock to file, print, and mail your proxy. So all this stuff has to happen in a very quick and tight window. And so from the in-house perspective, we spend a lot of time on trying to translate the actual conversation in the boardroom and how that played out and what the decisions were. And anything that hasn't changed or is not relevant to that conversation for the particular year based on the performance of the company, we really just we'll go through what ISS wants and try to check as many boxes as we can. We'll crib from peers. So I think that's, in practice, not helpful, but it's important to meeting the compliance of the disclosure requirements. And the second piece of it is really from smaller companies. Most of the public companies are smaller companies. There's just a sheer an immense administrative burden that is particularly challenging. And so a lot of this stuff, especially the prescriptive tabular disclosure, that's just a sheer get data, crunch numbers, put it in the proxy, that gets farmed out to outside advisors. And there's in a lot of cases limited benefit to the company from doing that. It's not like we're really examining the tables to learn anything about our program or how we stack up in different areas that the prescriptive requirements are asking us to disclose against. There's a real at a bigger company like an Exxon, maybe they don't focus as much on silly things like printer costs, but there's a real cost to pumping out those tables, making changes if the data has to change. If you're not sure who the NEOs are, that's really impactful from a cost perspective on actually getting the proxy ready and printing it. And I don't think that's an efficient use of investor capital. There's really only kind of like one or two people in HR or finance that are both, closing the books, getting the annual report together, actually administering payroll, and contributing to the disclosure. So we really try to focus on the meat of the disclosure, and that's kind of how I think about principles-based and the impact, for better or for worse, of the disclosure rules on the disclosure process.
So I saw Roland perk up when he heard Exxon. So Roland, do you have anything to add?
I appreciate that, and I appreciate the opportunity to key off of some of Zach's comments. And I'll just clear something up right off the bat here. Every dollar matters, right? So whether we're ExxonMobil or we're another company, every dollar matters, and it's a dollar back in the investor's bank, right? And I think that's really important to think about. And so to build on the previous comments, I would say when the SEC introduces new rules or regulations, it's really essential to balance, and keying off of Zach a little bit, what you talked about, this Venn diagram, but it's about the what, considering the time to produce with the why, really understanding the value provided to the investors. And because I like the example the first time, I'll give you another example just to kind of illustrate this trade-off that has to be made. So when the pay-for-performance disclosure requirement was put in place, the SEC estimated that it would take 15 hours to prepare. 15 hours to prepare. So some of you might be surprised to hear that it took nearly 20 times that to develop, review, and ultimately publish the disclosure. Our investors, our shareholders, are yet to ask me a question about it. So, in the spirit of every dollar matters, the ROI on those 300 hours isn't looking really good. And that doesn't even consider the effort in the subsequent years to continue to prepare and review it. Ultimately, it's a confusing disclosure that requires more effort to explain it than the disclosure itself. So if I think about the think big question, where the SEC has the discretion in the rulemaking, there's an opportunity to provide greater flexibility to tailor the disclosures in a way that is both fit for purpose while also being clear and simple. For me, it's clear. We should endeavor not to prescribe a disclosure that requires an explanation. If the disclosure can't stand on its own, it by definition isn't clear. And I think that's something that we should really think about. I recognize too, we can't be all things to all people. No one disclosure is going to fit all purposes. But, we've had a lot of conversation about principle, and I think this is where the discretion is provided, anchor on the principle. Identify the objective, and then stop. Leave the rest to the issuer to disclose in the context of their industry, their business, and their pay program. So I appreciate the opportunity to add a few comments to Zach's perspective.
So if we're going to get to the other two topics, we're going to have to do a hard pivot here, but I hope that everyone felt that we did a good job of tackling that million-dollar question better than my Chicago Bears did this past season of tackling defenders from other teams. So let's move to perks. Mark, can you once again come and level set for us and provide an overview of the perk rule?
Sure. I already mentioned the three key things that came out of the 2006 rules. The fourth key thing was not a rule, but it was essentially the SEC wading into the question of what's a perk for the first time in almost 30 years. To the surprise of many, the SEC provided guidance on the factors that should be considered in determining whether an item was a perk. They didn't define perks. It wasn't a bright line test. It was simply a way to approach the analysis that companies were going to need to make and had historically always been required to make on a facts and circumstances basis as to whether an item was a perk and then potentially reportable. This framework first examined an item's connection to the performance of an executive's duties and whether it was integrally and directly related to the performance of those duties. If the answer is yes, then the item wasn't a potentially reportable perk. On the other hand, if the answer was no, then there you had the second step. You had to evaluate whether the item conferred a direct or indirect benefit that has a personal aspect to the individual. And unless the item was available on a generally non-discriminatory basis to all employees, if the answer to that question was yes, then it was a perk. And I know many of you, and I'm sure virtually all of you at one time or another, in one capacity or another, has had to go through the process of analyzing items to determine whether or not where they fall under this particular framework. I think what has made it particularly difficult in the past several years are the unusual circumstances that we've faced where this analysis had to be made. I know during COVID, the whole issue of working from home, executive travel, introduced new facts and circumstances we'd never dealt with before, which complicated the analysis of whether or not under this two-step framework an item was going to be or should be considered a perk. And as we saw in the first panel, and we're going to be talking here in greater detail, the whole area of executive safety has now come into the spotlight because in the original 2006 release, when the SEC gave illustrations of the kinds of things that under this analysis would typically be a perk, they indicated that security provided at a personal residence or during personal travel would typically be a perk. And then they went on to say that a company's decision to provide an item of personal benefit for security purposes does not affect its characterization as a perk. And so those are is the guidance that we've had to struggle with both during the COVID period and now in trying to reconcile what I think many people believe justifiably is a business expense under this particular standard, because on the basis of the 2006 release, it sort of presumptively is a perk unless you can convince yourself otherwise.
Right. So Zach, can you dive into what companies need to do to provide perk disclosure from a resource, expertise, oversight perspective?
Certainly. And, this, I get really perky about this topic. I think it's really, sorry for that. Just kidding. So perk disclosure is a particularly challenging area of compliance. I was actually surprised to hear on the first panel you said that it was 2 to 5% on average of what the exec comp is what perks are. I was surprised it was that high.
The whole column.
Right. Right. I'm surprised it's even that high. Like, we spend so much time on this, and it's really challenging, and it really doesn't have doesn't drive a lot of the overall mix. The first thing that I kind of think about when it comes to perks is because of the ambiguity and because it really touches on such a broad constituency within an organization, is education and awareness. You really have to make sure that if you take travel and logistics, for example, that the business development and the travel departments, which large organizations might have, are educated on the nature and scope of perks, who the rules apply to, that someone with SEC compliance experience has a lens on the process and policies of those departments to make sure that the decisions are appropriate and that the information that needs to be raised to the disclosure level are brought forward. Because it's not always intuitive, you really have to educate the executives themselves. I think executives think of business expenses differently than how the SEC kind of thinks about the perk rules, and there might be a dissonance there that you have to work through, which for a smaller company can be challenging just because the executives might have more hands-on approach to logistics, or there just might not be a large department or a robust compliance infrastructure that's reviewing the travel of the CEO or other executives. So I think that education piece before you even get to monitoring and tracking is really important. And then there's just a sheer kind of resource and manpower issue that goes into tracking and monitoring perks once you've identified a particular perk or a program is established. HR, finance, legal, compliance, other internal corporate teams, security, et cetera, they really need to be involved. And again, that goes back to just amplifying the complexity of this for small cap companies where you might not have a lot of resources or there might not be as robust of an infrastructure around these types of things. To be able to get a handle of it and keep an eye on it is really important and challenging. And because of that, you need to get a lot of input from your key advisors, because it's a highly scrutinized and ambiguous sort of area. And then the actual act of making the calculations and running it through the disclosure is itself a complicated process. The calculation of incremental cost, is technical and complicated. Not small companies might not have dedicated tax professionals or accounting professionals on hand to be able to kind of monitor that in real time. You might have to get an actual driver involved in their spreadsheets. It's a lot of the times it's a manual process that raises other kind of like governance concerns from a oversight and control and manual process, audit and compliance monitoring perspective. So it's definitely an area that takes a lot of time and a lot of resource, and I think it would be helpful to get a little more guidance or broaden the threshold for disclosure, as an example, just to make sure that there's a little bit of more sensitivity to the amount of the administrative burden that the PERC rules kind of import on companies.
Thanks for that. Mike, given that we heard a little bit about the amount of work that it takes to produce this disclosure, I can say more, but I'm not. And we also heard as Zach said on the earlier panel, that this is a very low percentage of executives' pay. It'll be good to hear the other side of the role that perks play in investors' say-on-pay voting decisions.
Yeah, sure. I mean, I would largely agree with that. It's from our perspective, and I think this is true of many institutional investors, but I can't obviously speak for all of them. But from the Florida SBA's perspective, it's not a huge driver of our say-on-pay voting or just the analysis that goes into the say-on-pay decision. But it can be a red flag, and often is a red flag when they're excessive. There's kind of poor alignment if there's some kind of outlier activity with respect to the PERC item. It can kind of help us to, or kind of indicate that we need to dig a little deeper. We'll look a little closer at the comp committee operations. We may dig into, more broadly speaking, the compensation practices at the company if there's no individual equity plan, let's say, on the ballot. And particularly red flags when, like I said, when they're excessive or unaligned, but it can be the nature of the perks when they appear disproportionate relative to performance or even peer group activity. If they're a true outlier practice, that can indicate some issues where we need to do a little bit more research, where the rationale is unclear. And panel one, I think, talked about this a little bit. And that can affect, like I said, our confidence in the board, particularly the comp committee, and force us to kind of, have a elevated interest in that compensation and pay design at that company. And I think that's probably, in my view, probably one of the biggest criticisms by investors, just the rationale and the justification for it. It's either, nearly wholly absent, or it's very, very, poor in terms of its quality. And then another one would be where perks are part of retirement or severance agreements where there's no performance element. Again, a lot of these things are rare. They're kind of exceptional, but these are items where we would dig in a little further. And I think just to kind of summarize, we want to improve clarity and the usefulness. So the SEC could require a summary comp table version of perks, a summary level table that would categorize all the perks by type and cost, with the accompanying rationale for any high cost, outsized, or unusual items. And really, I think perhaps most importantly, we kind of have the perspective that perks shouldn't be disclosed in isolation as just, okay, we awarded X and it's worth Y, but really wrap that into the compensation structure at the company. So they are part of compensation, albeit perhaps a de minimis amount or a relatively small proportion, but they do represent compensation, and that should be factored in terms of the compensation design and philosophy.
So we're going to shift and expand on the conversation from the first panel on the SEC's position that executive security services constitute a PERT. David, let me bring you back into the conversation. Why is this so?
Well, Mark explained the guidance that was in the adopting release, and there was some background to that, I think, of why that guidance was in there about these particular security issues, and what the basic issue, and this was also very much clear from the adopting release in 2006, is the SEC was trying to say, we don't care about the tax treatment. All we're focused on is our own test of integrally and directly related, and does it have a personal benefit. And in the times before the 2006 release, this issue had come up in enforcement actions and in various circumstances where companies, with high-profile CEOs would get a security study done and put in place a security program, and from a tax perspective, that would allow them to avoid having to impute income to the executive for a significant amount of that cost. And I think people in the times before the SEC made these announcements about Perquisite framework, basically, would take the position that, well, we don't have to disclose the use of the company aircraft because that executive is directed to be on the company aircraft for security purposes. And so I think the SEC was really trying to draw the line in the sand there to say the tax piece doesn't matter. And what we're really focused on is you have to apply that integrally and directly related test. And when you apply it to the use of aircraft to go on a vacation or the implementation of security measures at a company, at a CEO's home, that wouldn't necessarily be integrally and directly related to the duties of the executive. So I think that was kind of the theory, but it also, I think, highlights this issue of, with perks, and sort of the elephant in the room is always use of corporate aircraft, right? But you have to have parallel tracks. You have to be looking at it from the tax perspective and how much income is resulting from that trip, as well as the perks perspective, and they're completely separate approaches and very different in the approach, where in the tax context you have sort of the civil rates and things that are more objective, whereas in the SEC context you have to look at the incremental costs and do a very deep dive into how much a particular trip costs in an aircraft. So I think that tax SEC dichotomy is sort of one of the primary reasons why this issue came up. But it's come up now in the spotlight again, but it's been an issue, I think, for many, many years around this question of to what extent security is a perquisite.
On that first panel, someone brought up the point of the tension between a lot of executives not wanting security services, but needing it, and then we as companies need to disclose it. So Roland, I'm going to go back to you all the way on the other side of the table and ask you, do you think that security perk disclosure negatively impacts the way companies provide security for their executives?
Yeah, it's a great question, James. And, I reflect on panel one as you did, when Deborah talked about the fact that it was an unfortunate reality. And then, Ani, you talked about the fact that the value versus the total reported pay, and, are we emphasizing too much, if you will, in this particular area? But I go back to, and I'm stealing words here a little bit, but I go back to what Bob McCormick said in the first panel as well, and I think he said it really well. Security is not a luxury, it's not a benefit, and it's not a perk. It's a necessity. And we talked about the fact that it's a cost of doing business. It's not a form of compensation. It doesn't belong as part of the total reported pay. It may get reported somewhere else, and that's perfectly fine, and that's a discussion for perhaps a different panel, but it's not part of total reported pay. And so to answer your direct question, I think the answer to your question is I sure hope it doesn't prevent companies from doing the right thing.
So, Brandon, how interested are you in seeing PERC disclosure, particularly with respect to security services?
So I hate to be the investor flying the ointment for the corporate issuer love fest that we're having around this discussion, but and in the spirit of trying to reach agreement, I actually want to agree with the statement that Ronald made, that every dollar matters. And for PERC disclosure as an investor, I believe every dollar matters. First of all, the disclosure of perks is important to inform investors because we, as shareholders, are the ones who ultimately bear the cost of providing those perks. Last year, the S&P 500 average the average CEO of an S&P 500 company received on average over $800,000 in all other compensation, which is primarily in the form of prerequisites. That's more than 4% of total compensation, as measured by the summary compensation table. And according to data from Glass Lewis, the value of CEO perks has grown 30% between 2019 and 2023. And based on our analysis of 2024 CEO pay data, all other compensation grew another 18% last year. So the use of perks, prerequisites, is growing, and I believe therefore should be disclosed. And the reason for that is because investors look at perks because it can be an indicator of a power imbalance between CEOs and boards of directors when negotiating executive compensation. On occasion, there have been cases where companies have lost their say-on-pay vote because of excessive prerequisites. Needless to say, it's a cost to the company that's ultimately borne by shareholders, and that the provision of prerequisites is not linked to company performance. I've yet to read a proxy statement, for example, where the company disclosed that the company's personal access to the corporate jet was dependent on meeting some sort of performance threshold, for example. The value of security perks certainly is growing, and it's not always clear that these expenses should be the responsibility of the corporation. Should home security, for example, cover the CEO's principal residence or a multitude of vacation properties? And again, it's the outliers that where this becomes a material factor. And I'll give you an example. Mark Zuckerberg at Meta in 2024 received $24 million in security perks from the company. $24 million is more than the average CEO of an S&P 500 company receives in total compensation. Now, what did investors do with that information? Well, Meta actually got a 90% vote on its say-on-pay vote, and it's probably because, I suspect, because Mark Zuckerberg is also willing to work for $1 in compensation. So if he wants to receive his compensation in security prerequisites, I think investors are perfectly fine with that, especially given the fact that he has over $200 billion in Meta stock, and so clearly has a direct alignment with the interests of other shareholders. But the disclosure of perks helps boards of directors and compensation committees push back on excessive requests for perks. We all remember the controversy with Jack Welch at GE's prerequisites or at Tyco. And the disclosure has a sanitizing effect by giving boards and compensation committees the opportunity to say no to excessive perk requests. And look, I get it. Look, security is important, more important today after the United Health tragedy. But there are limits, right? And so, for example, I don't buy the argument that requiring your CEO to fly on corporate jets for personal travel is a security risk, is a security consideration. Commercial travel is safer than general aviation. And frankly, I believe it's more a question of status and convenience to the executive than it is about their personal security. But if you want to make the disclosure simpler, I'd get rid of the incremental cost disclosure. The SEC's incremental cost disclosure for the personal use of corporate jets dramatically understates the true market value of that prerequisite. And you could simply insert the market value of that, or if not, the true actual cost to the company. Look it up on NetJets, get a comparable quote for that travel. I just find that, as the investors, we're paying for these prerequisites, and therefore we have a right to know their cost. And issuers need to trust their investors to be able to decide whether or not the perk is excessive. And we do that in analyzing CEO pay, as represented by Meta's own Say on Pay vote this year. Thank you.
I just want to add, sorry,
Go
one
ahead.
thing, and I'm going a bit off our script here, so I'm sorry, I'll be quick. I don't know what the answer to this is, but one thing that I think is interesting about the security as a perk question, and if the SEC is going to look at this and, make guidance or try to clarify this, I encourage them to also think about not just physical security, but cybersecurity as well. I think in a lot of instances, it would be a good business decision for companies, security personnel to, make sure that there's appropriate firewalls and cyber protections, and that there's that they're taking a look at the personal networks and personal devices of executives. And today that's a perk. I don't even really know how the internal people that are supposed to be monitoring this would even find out about that if that was a discussion that was happening, from an IT perspective and a policy of the company. But I think that's an area of security that, would be valuable to get some guidance on in addition to physical security.
All right, so we have 8 minutes to go and to shift now to speak about the NEO rule. So Dave, I'm going to come back to you. The SEC rules require certain disclosure for companies' named executive officers or NEOs. So what is the NEO?
Yeah, so if you look back through time, the disclosure about executive compensation and director compensation used to be sort of a mix of aggregated disclosure and then individual disclosure about the most highly compensated executives. And it was in the 1992 rulemaking when they really abandoned that sort of aggregate disclosure and went to basically a framework where you're looking at the CEO and the highest paid executive officers. And that approach really is carried through since that 1992 rulemaking. The only real significant change that they made in the 2006 rules was to make the principal financial officer also sort of a fixed named executive officer, and then reduce the number of other executive officers based on most highly paid to 3. So we kept 5 total, and you have the CEO, the CFO, and the other 3 most highly compensated. There's also the provision in the rule that talks about named executive officers who would have been among the most highly compensated but weren't because they were no longer executive officers at the end of the year. That you have to show 2 of those, which I think always causes some confusion and difficulty when you have that circumstance, and I always wonder just how much utility that disclosure provides. But the other piece of it I would just mention quickly is the threshold question is who is an executive officer, and that's not even covered in the compensation rules. That's covered in Exchange Act Rule 3B7. And there I think, companies struggle sometimes because there are specified executive officers in that rule, but also the notion of people who perform significant policy-making functions within an organization, and there it gets a little bit more murky and a little bit more subjective as to who actually gets into the threshold of being an executive officer and thus has to be evaluated as a named executive officer.
So, Mike, is the NEO group right from your perspective, or would you like to see the compensation of more C-suite executives?
Probably the latter. I think I'm sympathetic to arguments where it should be enlarged beyond the 5, especially at larger companies that are, more complex organizations where they may have, decision-making outside of that top 5 executive suite. You could have, any number of, I won't go into individual company names, but you could think of a tech company that has, a unique management structure where they have multiple units, divisions, product units that are clearly outside of the scope of the top 5. So I think that would make sense. You could also enhance disclosure in a number of ways or kind of tweak things in terms of the requirements. Also sympathetic to kind of scaling this based on size. I think that generally would work well in this instance. That's obviously applied in other, regulatory reporting requirements for, accelerated filers, et cetera. So I think that would apply pretty well in this instance. Like I said, kind of unit leaders or business unit leaders that fall out of the top 5, I think would, in my view, would, from an investor perspective, we would benefit from having that disclosed, especially when they have significant operational, influence. And then this is probably a lesser ask or lower materiality, but in terms of, more insight into members of management outside of the top 5 that are not explicitly required, succession candidates, other members of management that are coming up the ranks that are, clearly highly paid, but they just happen to fall out of the reporting requirement. I think investors would benefit from having more information on those individuals where there's, major incentive awards. They're obviously included in equity plans and the like, even if they're not technically an NEO.
Brandon, do you have a 1 minute?
I'll keep it very brief. So, the reason why NEO pay disclosure is important, yes, it's true that investors, by and large, mostly focus on CEO pay. However, we also look at how whether CEO pay is in alignment with how the rest of the C-suite is being compensated. And that relative compensation is important, for us to be able to consider. If the CEO is making many multiples times the other NEOs, that can have a negative impact on employee morale and productivity. It's the exact same reason why we as investors consider pay ratio disclosure, how much the CEO makes relative to the median employee, to be also a material factor when voting on say on pay votes. It's I'm trying to think what else I would want to make the point about, but I do think that the current balance of looking at NEOs is right versus all employees of the firm because the purpose of the disclosure is to address agency costs, right? And the fact that there's a potential for self-dealing when you have senior executives involved in setting their own compensation. Whereas for non-executives who are highly compensated employees, you don't have that same risk. And so that's why we have NEO disclosure. And I guess my last recommendation was that we do need uniformity. Smaller issues only disclosing 3 NEOs versus 5 for larger issuers makes no sense. It doesn't, in my view, reduce the cost to those smaller issuers because they still have to calculate the total compensation to determine which are the top 3 versus the top 5. And I think it would be beneficial for us to have a uniform definition that applies to all issuers for the benefit of investors in evaluating this information.
Thanks. To wrap things up, Mark, I'm going to go to you. I asked you to lead a few of our discussion topics, and here I'm going to ask you to end the panel. If you have any thoughts about the NEO rules, can you please provide that? Or, and forgive me for going into the third panel a little bit, but can you give maybe a 1 minute response on your brief thoughts, as I will, and I should be faster with this, on the impact of some of the rules that Dave mentioned earlier regarding some of the requirements that were added after the 2006 rule amendments.
Yeah, let me focus on the latter. Dave mentioned say on pay. To me, there were 4 major rules that came out of Dodd-Frank. Of those 4, the one that I think has proven to be useful is say on pay because it has served as a catalyst for ongoing shareholder engagement. And I think that was at least one, if not the primary purpose of that requirement. Today, you see not only companies that are engaging when they have a poor say on pay vote, but engaging year-round, and the disclosure is showing that. Now, whether we still need say on pay now that that fire's been ignited, I think remains to be seen, but that rule to me did accomplish something positive that was part of its intent. With respect to the other major rules like pay ratio and pay versus performance, they've been in place long enough that I think we kind of have an idea that the relationship between investor information and the compliance burden is out of balance, and that it may make sense to reevaluate those rules, given the fact that they were statutorily imposed. That probably suggests that maybe taking another look at how we can do something that may be a bit more consistent with the statutory language makes sense. Clawbacks, my mom understands clawbacks. If you get paid too much money and you didn't earn it, you got to give it back. I don't think we can kind of make a determination on clawbacks yet because the story hasn't been written there. I think everybody understands, and it was easy to put a comp policy into place. The hard part we haven't seen yet, which is the enforcement. Enforcement has only been in place for about a year and a half. Only compensation earned after October 2nd, 2023 is subject to recovery. We've still got another 18 months to go before the full 3-year look back kicks in. And I think trying to make major changes to the clawback rule until we know exactly what the scope and the potential problems may be a little bit premature. I mean, I think we're all practitioners are scared of the thought that a company may want to recover a large amount of money under its clawback provision, and the executive may not be cooperative. We've been lucky to date that the amounts recovered are small, or for the most part are amounts that had yet to be paid. So the whole recovery concept hasn't come into play. So there, I'm not suggesting that rule doesn't need to be tweaked. I'm just thinking we may be the kind of thing where if we do something today, we may be back doing it again in 2 years when we've really seen the full impact of what that provides.
I just want to thank everyone on the panel for making me look good.